The Equoland case, case C272 of 13, has looked at something that isn't often considered by the Court of Justice, the rules on customs warehousing. However, it's what the court had to say about penalties that is more interesting. The normal rules on importation of goods envisage the goods arriving at the docks, where the importer will make a declaration of their value and will immediately pay the VAT and duty in order to take delivery of the goods and to allow their release to free circulation in the EU. The import VAT can be recovered on the trader's next VAT return, but there's a cash flow disadvantage there. The import VAT has to be paid and then recovered, unlike the VAT on an intra-EU dispatch and acquisition of goods, where it will appear in and out on the same VAT return. If the goods are put into a customs warehouse or a free zone, then the goods on arrival are entered into the warehouse, and the importer makes a declaration that this is what is happening. This means that the import duty and the VAT is not paid on arrival, but can be deferred until the goods are removed from the warehouse and released for free circulation. This obviously gives one cash flow advantage, but the case report suggests that there's another one as well. It seems that some member states may then allow the VAT on releases from a warehouse to be accounted for through the VAT return, so it would look like an arrival from another member state rather than an import. So there would never be an occasion when the VAT had to be paid out now and recovered later. That might be the basis of what Equoland did, and it might also be the basis of why the Italian authorities didn't really like it. The trader imported some goods into Italy from outside the EU and declared them on arrival as destined for a customs warehouse. The import VAT was therefore not paid on arrival. The next day, the warehouse manager entered them into the warehouse register as arriving and immediately leaving. The importer then accounted for VAT through its VAT return as a reverse charge. However, the goods never physically entered the warehouse. By the time the authorities noticed, the VAT had been paid, or at least accounted for, on the next VAT return. The company therefore claimed that it had corrected the mistake it had made. The Italian authorities decided that the declaration had been incorrect and demanded the VAT on import again, plus a 30% penalty. Questions about whether this was right were referred to the Court of Justice. The Court of Justice ruled that the requirement in Italian law that goods should be physically placed in a warehouse to justify deferment of import VAT was not a mere formality. It was appropriate to the objectives of the VAT system. It was intended to ensure collection of the VAT and to prevent evasion. The directive did not preclude a law which required it. It's also not contrary to the directive for penalties to be levied for breaches. The details of enforcement of the system are left to the member states, and the directive says nothing at all about penalties. However, a penalty should go no further than is necessary to achieve the objectives of the system. If a penalty was excessive, it could be regarded as disproportionate and contrary to EU law on general principles. The court noted that the principles of neutrality precluded a trader being asked to pay twice VAT that should only be charged once, just because a formal system had not been complied with. That would effectively deny the trader the right to deduct the import VAT. The court noted that a fixed rate penalty may be disproportionate, particularly if it's impossible to adapt it to the specific circumstances of the case. Where an error had only resulted in payment being later than it would otherwise have been, an interest charge might be a sufficient and proportionate response. Of course, it may be that the Italian authorities regarded this as a deliberate attempt to manipulate the payment date and the method, in which case perhaps something a bit more punitive would be appropriate. But it's clear that 130% is a lot to charge for a short delay.